I did have a topic for today, and dealing with probably some of the three most challenging areas at the state level when we talk about cyber. First, it's often useful, I think, to start with an understanding of when I use the phrase cybersecurity, what is it that I'm referring to? My background will probably explain why I look at these issues the way I do. When I think of cybersecurity, I think of national security. My background is in national security, the legal and policy aspect of it. And I think that cybersecurity is just one more aspect of a nation's security. So whether it's protection from the DDoSes or making sure the DNS is secure or that routing cannot be hijacked, or you can also look at it from the perspective, a lot of the issues that I deal with, that the US government can continue to operate and have consistency and resilience in their systems, including the military. You want to make sure that the military systems are always capable and operating effectively. Also, it involves issues of IP theft. If the United States, as we are suffering quite a lot of in the cyber domain, IP theft, that becomes a national security issue at some point, and it has for us already. Also, the issues of malware, topics that you've already had a really good discussion about the technical aspect. The issues of malware can become a national security problem as well when that malware is used to challenge or negatively affect the US government or the viability of our economy. And it could be in a counterintelligence aspect that you look at this under national security and cyber. It could be in a defensive action under cyber command. Examples, I can talk about them to the extent that you're interested, such like Stuxnet. It's basically a use of malware to affect another state's critical infrastructure. So that's what I think of when I say cybersecurity. It's not necessarily from a technical perspective, because I'm not trained in technical background. It involves technical solutions and there are technical problems. But I come from that from a legal and policy perspective at the nation-state level. So what I want to do is update any of you who might not be aware of some of the current efforts ongoing in the international community and at the US level, forecast some of the developments of the critical issues in this area, talk a bit, and this is where I could go on forever, about how international law applies in the cyber domain and what are the challenges of applying it. And some of the emergence of the technology challenges, what are the core issues when it comes to the fundamental framework of the internet and how that impacts both the development of law in this area and policy. So first, the primary means through which states have attempted to deal with the dilemma of cybercrime has been through the passage of criminal laws, both at the domestic level, but also at the international level. We now have the European Union Cybercrime Convention that the US is a party to, and that is an instrument, the international legal instrument where to get at the problem of cybercrime, and it really focuses on having domestic law enforcement entities of all party states to the treaty cooperate after there's been an incident of a cyber incident, so they can investigate, share information. The intent of that treaty was to get an international cooperative framework to deal with cybercrime. The challenging part has been that some of the state offenders, if you will, states that we'd be most concerned that would have cyber crime and activity emanating from their country that negatively affects other countries, are not parties to that treaty. So Russia and China, for instance. So the instrument itself, while good, it has been criticized by many as lacking in real effective ability to stop cybercrime. Cybercrime has been recognized as one of the top concerns and threats, and it's not just for the US, but it is for other countries as well. How do we deal with it outside of the area of the treaty? Well, bilateral between two countries often is the best way to get agreement on how we will work through investigations of such crimes. The challenge is even when you have a bilateral agreement, what's called the MLATs, between two countries, there's a lot of disagreement as to what the terms of that treaty may be. When Estonia was attacked in '07, they asked the Russians, and for all intents and purposes, most people writing about this and thinking about it have opined that it was the Russians. There's been no clear evidence that the Russian government actually sponsored it. That'll be a challenge that I can talk about later. But the Estonians officially, through an agreement that they already had existing with the Russian government, asked for an investigation to be done by the Russians because some of the DDoS attacks emanated from Russia. I had the opportunity to bring the subject up a number of years later with one of the members of the Russian delegation when they were in DC, and I asked, you know, the Estonians have said that they asked you officially for help in investigating. The response then, and obviously, you know, that's not I wouldn't have found out a lot of information over dinner with the delegates that night, but the response was that they never got an official request. So there are challenges, let's put it this way. When you deal with cross-jurisdictional law enforcement cooperation, we still do it, other states, and we still could do a lot more of it, but there will be limitations to that approach using the criminal laws. But both the domestic laws and the international laws are working to tackle the issue on the cyber crime. What about cyber terrorism? So I've often been asked about this in the context of what is going on now, what is the concern in the future. And when I think of the three categories of crime and terrorism and conflict, state to state or state to non-state actor conflict, in the area of the cyber domain, cyber terrorism right now, while a concern by states, is not the priority of concerns. We have cyber crime in terms of dollars and value lost to individuals and state economies has been astronomical. Cyber conflict, the consequences of conflict in the cyber domain, which we've already seen examples of, and I'll talk about that, is also very disconcerting. And that's why the US had stood up our first cyber command in 2010 after the Estonia and Georgia incidents. So, but cyber terrorism, I've described to folks, while we want to think about it in terms of what will be the policy and legal frameworks which we operate when it happens, we have not yet seen the equivalent of a 9/11 in cyber conducted by terrorists. So while what the government knows, and the intelligence community has given threat briefings, threat assessments on this, is that terrorists have sought and do use the internet. Most of their use of it is for recruiting, for the movement of logistics, for propaganda. But for the actual, if you will, the 9/11 effect using cyber, the cyber weapons and networks, we have not seen that yet. Although in my cyber class, in assigning papers just this semester, I encourage my students to think about that now. What will be the legal framework which the US would operate under in response to any cyber terrorist attack against the United States or our interest abroad? When I worked in the intelligence community and at the White House, it was always an issue of you have current issues that are in your inbox and you don't really have time in the intelligence community to think of those long-term issues, things that are 15, 20 years down the road. And often, unfortunately, they get put off. And I describe the cyber terrorism issue in that category, that it's not a current day inbox, high-level NSS problem at the White House, but may well be, and most people expect that it will be in the future, and therefore we need some good people to research and think. Both technically, the technical issues will probably be some of the same in the other arenas of concern of crime and conflict, but more about the law and policy, because they will probably be different than, and should be, than how we deal with the crime in cyber versus a terrorist attack versus even state conflict. And so on cyber conflict, which in the last number of years, have spent most of my time on, what has been going on? So when we think of state cyber conflict, it's the use of the internet. Not that even Dick Clark in writing his book and talking about cyber war, when people talk about cyber war and cyber conflict, it's not that the expectation will be a virtual war. I know there's some movies and science fiction movies that are out there, but that's not what we're expecting to see. But what has already happened and what we expect to see continue to happen is that states involved in conflict will use cyber means as part of a conventional kinetic warfare or engaged in hostilities. That is what happened with the Russia-Georgia 2008 conflict. That conflict was began with a cyber, and I try not to use the word attack because as a lawyer, as an international lawyer, it has a certain definition, and I'll get to that. But there were cyber operations by the Russians targeting Georgia before their troops moved into Georgia. So compromising the Georgian government operation online, and not just the DDoSes, but DDoS was part of it. So that what we expect to see, and what often the China experts also have talked about is, if there is a conflict with China and the US between these two states, that China, we know, has significant cyber offensive capabilities, like a number of other states, us included, as I've heard from folks who've spoken about it publicly, of course not in a lot of great detail, but I'm confident we have that capability as well. But it would be in a conventional conflict with China that we would see them using cyber against the United States. And General Alexander has recently spoken about this. During the summer, he spoke at the DEF CON conference, as well as the Aspen Institute at their Security Forum conference, talking about the concerns. And Secretary Panetta has recently made a number of speeches that have got a lot of attention about what he's concerned about with respect to cyber. That is at the state level right now, concerns about a handful of states that have the capability and have shown their willingness to use that capability in the cyber domain against another state. So what's the update on current government and legal community efforts? So a number of international organizations and the US and individual states have been working on all three of these issues: the crime, the concern about terrorism in the cyber domain, and conflict. So some recent examples: NATO has recently taken the first step towards making cyber conflict through their organizations an international effort. They've just opened up their in 2008, so it's a little dated, but seems just like yesterday, their Cooperative Cyber Defense Center of Excellence in Estonia. Working with a number of the folks at that center, they've done a lot, and most recently, anyone interested in the law have come out on their website. They've released it. It's not Cambridge Press, I believe. I've been told it's supposed to print it at the end of the year. Come out what they have called the Tallinn Manual. And I think that was a great effort by that center, the NATO center. And what it does, the Tallinn Manual is quite long, but I encourage anyone who wants to get lost in the details of international law and cyber. They brought together a group of international legal experts from a number of countries, the US being represented as well. No state is backing up this manual at this time. It's not actually. NATO center kind of facilitated the writing of this manual. And the significance of it is international law develops through an understanding between states of what the rules are in a certain domain. And historically, over the years, there's examples of lawyers, the international lawyers, getting together and writing about a specific issue. Sometimes it's warfare. The San Marino manual was about warfare on the high seas. Why it's significant that they wrote this manual even without a state saying that we're committed to it, we believe this is binding law, is that this can open up a debate about what the rules are that are applicable in cyber when it comes to the laws of armed conflict. And I'll talk about that a little in a few minutes. Hopefully I don't talk too long. So NATO has done a lot. The European Commission has proposed to establish a European Cybercrime Center. They came out with this announcement in March of 2012. Interpol has set up they're building it as I speak. It is estimated to be built, I think in 2014, finished, their innovation center in Singapore. And that is where they're going to have, their focus on be digital cybercrime. So a digital database for cybercrimes. So these are a few examples of the international organizations. The UN has been involved, and the US has been involved with the UN and these other organizations through a group called the GGE, the Government Group of Experts. The U.S. is a party. There are about 18 other states represented. They're coming together. It's under the first committee of the UN, the Disarmament Committee. Some lawyers discuss as to whether that's the proper location for the discussion of cybersecurity issues. You can go to the website and see the U.S.'s position paper, and I think they just had their second meeting. But what that group is trying to do. It's not trying to solve all problems, but I'm highlighting some of the efforts. Some of the other interesting efforts, I just came out last week from a meeting with the IAEA. I thought it was really interesting that the IAEA, of course the International Atomic Energy Agency, has stood up as part of that organization something called WINS. Part of what WINS is doing is looking at the cybersecurity of all nation states' nuclear power plants. Now, we can discuss about how limited the IAEA is under its international legal authorities. It has authorities to do inspections, but it is very significant, I thought, that this issue is now part of the agenda for IAEA. Now, what is often ironic is, under international law, it's not unheard of. It usually happens this way. Usually, international organizations are either started by the U.S., even if it's just an idea, even when we're not even a party to it at the end of the day, or they come to the U.S. first for help and guidance. That usually is just an indication because we're farther along, maybe addressing some of the issues. So the IAEA has come to the U.S. and has been working with a number of folks, and particularly the nuclear power plant operators in our country, to see how they're setting up their standards for cybersecurity. They are excellent at physical security. This is part of their culture and how they live and breathe, which is good for everyone that lives in the United States and the international community. We wouldn't want to have a leak of radioactive material. But they're also putting on their radar screen, I wouldn't say it's quite fully culturally incorporated yet, the issue of cybersecurity. But the IAEA as an international organization is actually taking that up. First, we're looking at the United States and how we do it, also taking it internationally and trying to determine whether we can also hold other states responsible for securing their nuclear power plants to a certain level with respect to cybersecurity and not just physical security. And there are a lot of bilateral agreements, bilateral efforts between states to work on developing agreements on what are the rules when it comes to conflict. Right now, we do not have, there is not an international multilateral treaty with respect to cyber conflict. In 1998, the Russians were the first to propose such a treaty at the UN Security Council. And remember at the time, in 1998, the US, it was, I wouldn't say they actually laughed, but it was laughable what the Russians were proposing. In a nutshell, what the resolution was proposing is that the treaty would prohibit conflict in the cyber domain, and it would prohibit the use of cyber weapons. So it was unrealistic from the perspective of the US at the time. What has happened though, and I think, which is good, at that time in 1998, there was little to no discussion about that issue between the states. And there wasn't for a number of years. I'd say 5 to 7 years ago, what I've seen is a very good step forward in that these countries, including the US and Russia, are speaking about this very issue. We're still in disagreement, and most recently at a conference at Georgetown that I ran, the Russian official was sitting on the same panel as our US officials, and the Russian proposed and pushed what they've been pushing since 1998, an international treaty on cyber. And politely, the US official from State Department said, and we still today, we politely disagree with you on that it's not the stage. I, as an international lawyer and teaching students, a law professor, I don't say that it would be unrealistic to have one. I say that there would be benefits to having one. There are a lot of benefits in a number of treaties that we have with other countries. Realistically, I don't think it's going to happen in the next decade or two. So while I do think it's important for some folks to work on that issue, I think it is very important to work spend more time and effort on this bilateral agreements between states, because a lot more can be agreed to about particular activities that you want to take off the table as optional, or agreeing on what targets in a conflict should be off the table. And you can do that under international law in restrained behavior by those negotiations without having an overarching treaty. As one of the most challenging aspects of a cyber treaty would be, as we found with the chemical and biological treaties that we have signed, and so have the Russians, is that verification is very difficult. Even in the chemical and biological arena, it was virtually impossible for the US ever to know, through verification means, that the Russians were lying and cheating in those conventions that they had signed, and they were. Cyber, the challenges of attribution, some of which, it's a technical issue, but it affects how the laws and policy will either be useful or not. So the attribution issue truly challenges in cyber the ability for any verification of an international treaty on the topic. So it may be that we would just be revisiting the situation where, with respect to our chemical weapons treaties with the Russians, and not having a belief that they would be agreeing to the same restrictions that we would be agreeing to in that treaty. So to the subject that I spend most of my time on as of late, how do international laws with respect to the law of armed conflict apply in the area of the cyber domain? So I'd say about 4 years ago, when I would speak about this, I would be asked the question whether international law, and focusing on those laws related to conflict management, were even applicable. And I would be challenged on that. Well, why are they, my opinion then was that they were, still is, but there was an open question as to whether it would even be thought of that they would be applicable. Well, so a few things have happened that made it a little easier to talk about. The United States government, at least, and other states, not all, which is the dilemma right now, the United States government has recently come out and officially stated that as a the U.S. policy position with respect to the laws of war and armed conflict, that they are applicable in the cyber domain. It's very significant. That means that when the president says that our military and our intelligence agents, our FBI, the entire U.S. government personnel, when engaging in cyber conflict, will abide by those rules. Other states, as I mentioned, have not. In fact, other states like China, in a number of different ways, have indicated that they do not believe that those rules are applicable in cyber conflict. And that is disconcerting. When you have, in international law, with respect to conflict, when you have a disagreement among states and no treaty yet, right, no agreement, and even in their rhetoric, they are saying the opposite with respect to whether they think rules are restraining of their behavior, it is disconcerting, because then you're left with uncertainty. When we're engaged in conflict, then what are the rules going to be? Thankfully, I think the US has learned some lessons about even thinking that there is a space, even if it's Guantanamo Bay, where law would not be applicable. I mean, I think we've gotten over, well, I think we're still getting over that, but there is no such thing as a space, whether it's land, air, sea, where there's no applicable law. And to say there is none in terms of international law is very dangerous for us as a state, even if we are the most powerful one, even if we are the detainers. It is very dangerous, certainly for the international community when we talk about cyber conflict. So the US is currently working with other like-minded countries to try to see if we can get some agreements on some of the rules, which are the basis of the Geneva and Hague Convention and the UN Charter, whether, even if we can't get a comprehensive treaty negotiated by multiple states, we can at least get an agreement for those states that we might be most concerned with. So not just talking to our friends, but talking to those states that are not as close to us, like Russia and China on these issues. Speaking with them may be actually more important, not to exclude, though, what I know is being done, and importantly being done with other countries as well. So we do know that the US reorganized itself with respect to the military dealing with cyber. After the Estonia and then the Georgia incident, Cyber Command was stood up. Now, Cyber Command has gotten a lot of public review, but also a lot of raised questions by other states and individuals as to whether the US has militarized cyberspace by even creating the command. It is almost a moot point to even discuss that anymore. I live in the world of law as it is, not law in that I hope it may be one day. And as it is, Cyber Command is stood up, and other states have stood up their equivalent of Cyber Command. The reality always was, I believe, that the cyber domain would be no different than any other domain, and states would use it as when needed, particularly from a US position in self-defense, would use it as a means where they would also defend themselves. And some other states will choose to use it as a means for more offensive weapons used against peoples and states. So international law, if you're interested, what are the laws that she generally keeps referring to? So there are two bodies of international law which are relevant here. There's what's called the laws that are related to the recourse to the use of force. And that is embodied in the UN Charter, in customary international law, and state practice. Those are the principles of international law that say when a state can lawfully use force in the international community, in international relations. Article 2.4 of the UN Charter explicitly prohibits the use of force, the threat or the use of force against any other member of the UN membership, so basically all states, right? Against the political independence and sovereign integrity of another state. That's an absolute prohibition, except there was recognition at the time, and two of the exceptions are codified in the treaty, the UN Charter. Except if the UN Security Council gives you authorization to use force, then in effect you're not prohibited from using it under 2.4 and under 51, which is of great topic and interest in cyber, and that's the word attack. That's where I focus on, and why I often don't use the word attack. I would rather describe the cyber operations. They may amount to an attack, but Article 51 of the Charter is our second exception to the use of force, and that is that every state has the inherent right of self-defense. In fact, it says it has the inherent right of individual or collective self-defense. But that's not all it says. It also goes on to say if it suffered an armed attack. It goes on to say also, not as critical, but until the UN Security Council takes the matter up. So an example in the kind of the classic terrorism, counterterrorism world that you can equate to the cyber issues, and there's a lot of analysis that is being done on this. 9/11 was clearly an armed attack against the US. And the US had the legal authority to use force, lethal force, in self-defense against those that perpetrated that attack. So you would invoke Article 51. The US and other states have invoked Article 51 over the years numerous times, including in the counterterrorism field as well. In 1998, the President authorized military strikes against terrorist training camps and a pharmaceutical company in the Sudan. That was after the embassy bombings. Article 51 was invoked. So there are a number of, that's just an example. In the UN, under the cyber scenarios, you can also equate certain operations that might reach the level of an armed attack. That is where saying the laws apply is now easy, but still where the work remains is how those laws are applied. That is always where the devils are always in the details, and they certainly are when you apply the laws. So there's two exceptions that are built in the Charter. The other exception is under customary international law, and it's often referred to as anticipatory self-defense or preemptive. We'll separate that out from preventive, where there is no such thing under international law, but preemption, anticipatory, that is under customary international law and was developed under an incident, believe it or not. I don't know if we have some Canadians here. My students are always shocked by this. In 1837, the US and Canada were on the verge of a major war, believe it or not. And there were a bunch of rebels in Canada that were trying to break free from the British regime. And they recruited some Americans up north, not so far from where we are, to assist them in shipping things to them, supplies. They volunteered, individuals. So there was this private ship called Caroline, privately owned American ship. The Canadians knew it to be being used to ship supplies and people from the US into Canada that were helping the rebels. And so the Canadians attacked the ship, actually set it on fire, killed 2 Americans in the meantime on the ship, and then threw it over Niagara Falls. That principle that was developed between a correspondence between the then Secretary of State, Daniel Webster, and the British officials through letters became known as what is the threshold a state must meet when dealing with a threat that resides in another country, and it's a non-state actor threat, and the Canadians argued we needed to use force in self-defense. Ironically, the facts of the case were not about anticipation of an attack. The rebels were already attacking Canada. So this was just a customary principle, the UN Charter didn't exist yet, not codified in law, and most of the scholars believe this carried forth with the Charter. So now, how do we apply this customary principle of self-defense? The UN Charter legal authority used self-defense, and now let's apply it to the cyber domain. And so that's where I've spent most of the last 5 years working, and if you want to look at the Tallinn Manual, I think it's an excellent example of them doing just that, trying to apply those rules. Some of the challenges, because I want to have time for questions, and I'm just going to tick them off because challenges dealing with law and policy. I mentioned one really big one, and that's attribution, the difficulty of knowing who is responsible for that use of force that might be illegal or that armed attack. And in the crime area, who's responsible for that theft. But at the state level, it gets even more complicated as you can bounce through jurisdiction in different states. What are the limits, and there are, on the law enforcement efforts done internationally? And there are many. The use of proxies has become very challenging. How do you get behind the proxies to know when a state is actually responsible for the illegal activity on the international realm? International law requires that you show who is guilty of that illegal or unlawful act. Showing that through attribution challenges is hard, and what if it is a front, it's a company, it's students. But the government itself, and this is exactly what the Russians said with respect to the Estonia incident, it might be the code might be written in Russia, but that doesn't mean it came from the Russian government, and it might be coming from the patriotic hackers in Russia. But that's not the Russian government. So the proxies become a challenging part. The lack of agreement on terms and the norms, as I pointed out. The issue of what takes precedence, the argument of state sovereignty or freedom of access and freedom of speech on the internet. So you've heard Secretary Clinton come out a number of important speeches, and including after the incident with China and Google, and emphasize how the US's position is one of freedom on the internet, open access. Other states don't agree with us on that. China puts forth in all the diplomatic discussions, first and foremost is their right of sovereignty. And you can't really ignore that. It's a fundamental legal principle under international law that states have had, at least since the Peace of Westphalia, and still do. These can be diametrically opposed at sometimes. Free and open versus a state arguing through its sovereign right has the authority to close its country off from the broader internet, to limit speech on the internet within its country, so its own citizens don't have to read or promote any threatening language towards the regime. So those different disagreements on terms and norms become difficult to rectify when we try to get agreement in the international level. We also don't know the full extent, as you've heard in the discussion this morning, which was excellent, we don't know the full extent of the threat or the damage. The issue of lacking of mandatory reporting requirements is troubling. Limitations in information sharing from both the private to the government and the government to the private for different reasons. Lacking enough of that. The good news is for some of the mandatory reporting, the SEC, the year before last, or last year, if I forget, keep track of the dates, I'm getting bad at that, now requires, at least for those publicly traded US companies, that when a breach reaches a certain level, and this is where the lawyers get very involved about deciding, well, what does that word, a significant breach mean? Right? Well, when that happens, if there's agreement on that, they have to at least report that now. That's a beginning. beginning step where we need a lot more reporting in a lot of the other fields. The lack of agreement on who and what should govern on the international level and set the standards for the internet is very troubling. Again, states are not in agreement on this. Some say the UN. Well, the U.S.'s position with respect to the ITU is not one where the U.S. believes that the ITU should be in charge of governance of the internet, for a lot of reasons, some of which are not so, not so crazy, I would say. There are some reasonable points they bring in. So where should it be? If not at the ITU, the GG is one process that started at the UN under the first committee, Disarmament Committee, not probably where you want it to stay. IAEA is making good efforts. I've worked with a judge from Norway, Judge Stein, and his idea that he writes quite a lot and speaks all over the world about is the ICC, the International Criminal Court, should have a new crime, cybercrime. Good idea. The reality of getting a new crime in front of that court and the complications of getting an agreement on what is going to be constitutive as international cybercrime is very challenging. Okay, I'm going to open it up for questions. I was going to go over a few of the more of the U.S.'s positions, but I've tried to roll some of that into our discussion. But I've been asked to remind, if you have questions, if you could locate one of the microphones so it can be properly, I guess, recorded and captured.
I have a question. You're talking about the difficulty of identifying who is actually responsible for various proxies. But what about the notion that you have a nation state that's not tied to a geographic area? What is international law about, say, for example, just rough example, negotiating with anonymous, not that you necessarily know who to negotiate with?
Yeah, so non-state actors. Important issue in international law. You would not negotiate a treaty with a non-state actor. Under the Vienna Convention on the Law of Treaties, only states are parties to treaties. That does not mean, though, that individuals and groups, including armed groups, even including terrorists, that they don't, international law doesn't apply to them. It does. They both have rights, these groups, under international law, and they also have responsibility under international law. It's just that they won't be a party to a treaty. So you would assess the action. What is it they're doing? Now, here's where people tend to, they conflate the different areas of law and almost feel overwhelmed that they can't resolve it, but it can be resolved. Sometimes things, actions, operations can be two things at once under the law. So even in terrorism, as we find in the cyber context, you can have a crime that is also part of a conflict. And it could be, and I'm not going to go down this road because we would be here for hours, it could be called a non-international armed conflict or an international armed conflict. If you have an organization, I'm not saying this, but if your organization like Anonymous were to be equated with, and I am not equating them, so, because I know it's recorded, just let's not make, be clear I'm not equating the two, but let's hypothetically discuss it if they were like a terrorist group. Right? So agreement on what is terrorism. What you'd want to focus is on what is the level or the consequences of their actions. Is it a crime, sporadic, limited, bad? I'm not saying that, but is it categorized as a crime versus what international law does, says that international law doesn't deal with crimes outside of the, like a cyber crime convention. The laws of armed conflict are not meant to deal with crime. Those laws, when you can actually use lethal force against an organization, they're meant to deal with large-scale violence, which could also be a crime. So you would want to look first at their actions, how you categorize them. What a group, even a terrorist group, is doing is a criminal act, but it also is armed conflict. They are an armed group in conflict, so it depends on their violence, what they're doing. But it would be under the non-international laws of armed conflict if you would categorize a group. We have not gotten there yet. When I talk about cyber terrorism, thankfully, I wouldn't put it off the table, though, as one day we may see a group, not anyone that exists today probably, but a group that uses cyber to conduct the equivalent of what would be a high-level, grave use of force, reaching the level of violence that even international law would say the laws of armed conflict apply vis-a-vis this group. So you can't have non-state actors. They just wouldn't be treaty parties. They just can't sign a treaty. Most of these groups would not be interested in negotiating a treaty. In fact, most of them like the benefits of being protected by international law and also love the ability that they escape any of the responsibility.
Thank you.
Well, of course, I'm not a lawyer, but I'm always fascinated by these discussions of the overlap of law and policy to cyber. I wonder, can you sort of provide some context around what maybe war crimes would look like in a cyber context? Is it even applicable? Are there certain actions, certain cyber operations that you feel would qualify for some war crime trial afterwards of people to be held accountable for what they did?
So I don't rule it out, and this is where Judge Stein is brilliant. The judge that I've worked with from Norway, and we're working together on a East-West Institute project on the task force for cybercrime. When you think of when we examine international law and what war crimes is defined as, it is a specifically defined crime now under the International Criminal Court, where I don't think actions on the internet would reach a level that it would be a war crime. I do believe you could have cybercrime become, as Judge Stein has worked on, passionately, in fact, that you could have a separate crime that could be under the auspices of either an ad hoc tribunal like Rwanda, Yugoslavia tribunals, or at the ICC, the permanent standing International Criminal Court. But you wouldn't, I don't think it would be as effective to try to get it under the already existing and internationally accepted definition of a war crime. You'd want to, I think you'd have crimes specifically like terrorism. There is no universal definition of terrorism. There is no crime against terrorism before the ICC. But you can criminalize certain activities that terrorists conduct and have that brought under these international courts, or even importantly, most likely, into domestic courts. So if you see, I think you're better off strategically in developing the law, look and criminalize the specific acts, and instead of trying to say, well, it's going to amount to a war crime.
Is that just because the harm to individuals is somewhat limited from a cyber perspective? Is that what you're...
Yeah, so you wouldn't meet the threshold of the legal definition of war crime.
I see.
Yeah.
So this week there was a report that came out that said many hospitals' primary care devices are running older versions of operating systems, and they're finding that many are infected with malicious software as a result. And the manufacturers of these devices won't allow newer versions of the software to be installed because there are FDA requirements and things like that. So with that as background, what if in the course of a conflict, an adversary, I don't know, shut down healthcare systems in a number of hospitals across our country? Would that, and people died, would that rise to the level of a war crime?
So what I would say is applicable, if you're talking about armed conflict, right? If we are in armed conflict with another party, be it a state or an armed group, right? Under the Geneva Conventions and the Hague Conventions would be applicable. Under Geneva, there are the gravest violations of that convention are constituted as war crimes. So what you would likely see is that through the conflict, if there were incidents that rose to the level of grave violations, right, where targeting civilians rose to the level of a war crime, then you could, well, one, detain the individuals, right, that are conduct as combatants during your time of conflict. Right? You could also, unlike POWs, you can try those individuals at any time during or after the conflict. I would say what I would think you would do is after it, at the domestic level, right, try some of those individuals for war crimes versus trying to get it to the ICC at the international level where there's lots of challenges.
Congressman Rogers from the House Intelligence Committee was here this morning. I don't know if you were here for that. And he talked about a bill out of the Intelligence Committee that has been passed by the House, but I guess is stuck in the Senate, that would create a statutory authority for better sharing of cyber attacks, cyber incidents between the government and the private sector, so that if the government is aware that there is this major intrusion out there and has the source code, they can share it with the private sector and vice versa, so that the country is in total better prepared. Do you have an opinion, perspective on the value of this particular piece of legislation?
So I think if you lined up everybody from every political party, from every government agency, and every individual that works anywhere in the private sector, they would all say the same thing, and it would be information sharing between the public and private is good. So we'd all agree, yes, let's do more of that. What is difficult, and I will not claim to know the nuance of political jockeying on the Hill and what even complicates things in the substance, beyond the substance. You can agree that it's all good, but it is the two sides of this, the private and the public, have different views as to what needs to be shared and at what level of detail. Their positions are different because their equities are different. Private sector, concerns about competition between other companies that do the same as them. They'd be giving away their secret sauce type of thing to other people at times. Security companies, certainly. They're also concerned about liability issues, right? Freedom of Information Act, right? Whether it would cover them when they give their information. The government is under the Freedom of Information Act. If I give this to you, government, are you then going to respond to Joe Blow who requests information? You have to, under the law, under FOIA, give it to him. The government's perspective, and I'm very much minimizing, it's a lot more nuanced to what I'm saying. The government's perspective is, of course, they want more information sharing. General Alexander recently even said in one of his hearing testimonies over the past year, he acknowledged that there is a program that they've been doing, the pilot program, the DIB, where the federal government picked a number of the defense contracting companies that they already have a lot of information sharing with, and they created this program to get more information sharing on threat vulnerability. He admitted in his hearings, he said, and he had, to my knowledge, and I've asked around, this is the first time that it's ever been acknowledged officially, that the information that he, because some people believe Cyber Command is all-knowing, reads all of our stuff, knows everything about our lives and every threat in the world. He acknowledged that the information that they were getting from the private companies was new knowledge, new information so recognizing the government gets a benefit out of it. The concerns on the government side is how do we get that information that the government believes is sometimes called sources and methods or sensitive classified information out of the government and shared with people who don't have clearances, don't want clearances, and you don't want to limit it to people with clearances either, right? How do we get that to a level where, and how do we maintain our countering capabilities, counter intel, right? Counterterrorism in the cyber domain. Because we need to be ahead of the curve, right? To be good at countering something, you need to know what the vulnerabilities are so you could also exploit them, right? How do we maintain that ability as a government, right? A government agency that's responsible for defense and offense, at the same time giving information out, right? So one view is don't say anything, because then we'll keep everything and we'll be able to do what we need to do. Well, that is untenable, and so now it's a conversation is how much and in what format it can go out, right? And clearly it's got to be at an unclassified level. So how to do that is what is of a lot of disagreement. It shouldn't be an all or nothing, but it's the kind of how and to what level.
Thank you.
Hi, you mentioned Stuxnet earlier, so I feel that this is a fair question. A New York Times article was cited as saying that the United States and Israel collaborated in a project to create Stuxnet, and they dubbed it Operation Olympic Games. Do you feel that traditional rules apply in that case? And did you invoke Article 51, or was this a preemptive strike? I feel as the United States, we have to set a good example for other countries. How do you justify it?
So, well, I give in my classes, a lot of people are sensitive talking about Stuxnet. That's easy for me to say that we shouldn't be that way because I'm not in the US government right now. So I give it as a hypothetical for my students, actually, analyzing the laws, and I've talked about it openly in interviews and on TV. And Sanger is great. So I don't care about who did it. It doesn't matter. I do listen to the technical experts. I believe those that have said this is a complex code, complex enough that a state or 2 states would have been involved in it. Okay, that's where I stop. Now let's look at this as state action. So remember how I don't throw out the word attack? Because I say, what was this operation about, right? What was the effects of the operation? And then you would look under the laws that I've just discussed with you, Article 2.4, Article 51. You would also, though, which, you know, if you have a lot more time, I can give you those citations. You'd look at the International Court of Justice's opinions, the ICJ. Particularly relevant one is the Nicaragua decision, 1986. The U.S. is not a big fan of it, of course, because, you know, we were found guilty of violations of use of force by the court. This was the mining of the harbors, arming the Contras in Nicaragua. Anyway, that court did a specific important thing for international law, and it analyzed use of force threshold in Article 2.4 and armed attack threshold in Article 51. And it divided the threshold. So a use of force, it made clear, is not the same as an armed attack. Use of force, when you suffer a use of force, that use of force may be illegal under Article 2.4, but it importantly and significantly doesn't give you the right to use lethal force in self-defense. You can do countermeasures, right? The court case talks about, like economic, non-forceful countermeasures. You can go to the UN Security Council and complain, right? You can do a lot. You can do economic, sanctions. If you suffer an armed attack, however, importantly, that's why the court makes a distinction. An armed attack, nicely, they don't give that definition to us in the case, of course, to make things more difficult. But it says it's those grave uses of forces, right? So not the border skirmishes, but grave uses of forces state to state. And that, under those cases of armed attack, right? I gave the example, an easy one of 9/11, but it does not have to be just conventional weapons. And the ICJ, in its nuclear weapons opinion, said any weapon qualifies under this analysis. So cyber must be analyzed under these laws, to your first question. Now the only question is whether you, in analyzing the effects of Stuxnet, not the kinetic explosion of a facility plant, not the death of anyone, but taking off, what did they estimate, about 1,000 centrifuges which failed to work properly, slowing down a state's nuclear uranium enrichment program. Look at those effects, and now under the law, based upon developed international law precedents by court cases and interpretation of the UN Charter, and importantly, state practice, which makes international law, then you would tell me, is that an armed attack? What was that use of that malware? And you would analyze the effects. Did that amount to an armed attack? You want to know kind of my academic, theoretical? Okay. If you take a strict reading, and there are people who say Nicaragua is bogus, the U.S. administration might say that, right? Or, we walked away from that case, right? We walked out of the court saying, okay, we don't like where this is going. We think this is politically motivated. We're out of here. They still ruled against us, even though we weren't in the court case anymore. But if you take a strict ruling, interpretation of what that court said, and I would encourage you to go and read the whole opinion. It's fascinating. And you look at state practice, and I may be in the minority on this, right? And I mean, meaning there might be US lawyers, government lawyers that disagree. I would say strictly on the interpretation of use of force, what is an armed attack under international law, historically, the effects, the use of that malware against that facility did not amount to an armed attack. Now, you still have to go through analysis of use of force, violating sovereignty. We've spied, espionage has been conducted for, since the beginning of time. Believe it or not, my students are always shocked when we get to this part. International law does not prohibit espionage. Does not. There is no treaty that prohibits it. In fact, there are treaties that recognize the unique position of spies. In fact, the Geneva Conventions say there may be spying in conflict. So a spy, while he is committing a crime, a domestic crime of the state that he is in the conflict that he is in, he cannot be summarily, or she cannot be summarily killed. You can try them, domestic. But international law, so flame, you mentioned Stuxnet, we might as well go for flame. I mean, okay, so it depends on the audience. Some people might think I'm crazy now. As a as a cyber tool, right? Say we're in the hypothetical world of a university and what's cool, and I'm not technical. I'm fascinated about the capability of Flame. Flame was a collection tool, not a tool of sabotage, right? Not a tool of use of force. It was an espionage tool. But it took espionage to the new age, because now you can do it through malware. You know, there were some things that were old hat in terms of capability. Keystrokes, well, states have been able to surveil keystrokes, believe it or not, on your computer for years, right? For years. But the ability to, this is the part that I kind of thought was fascinating, not that I'd want someone to do it to me, that tool, Flame itself, was able to collect the conversations in Skype. That had always been a challenge for, let's say, an intelligence organization, or a technical challenge. So I was like, wow, great capability. Now, I'm a lawyer. Now you say, was it lawful? Well, internationally, spying goes on. Customary international law, everyone does it. And so you can conduct, and if you get caught, though, you could be tried in the domestic court systems, because just about every nation state criminally codifies or prohibits under its criminal statutes, like our espionage statute, in their country. So if you get caught, you could. The reality is most spies don't get tried. They get, person non grata, kicked out of the state. You would, read that in the newspapers, PNG, they call it. And they're usually swapped, we tick somebody off, they kick our spies out, then we kick theirs. So that's spying. So Flame, related to Stuxnet, different analysis. You would look at the use of force, use ad bellum, and UN Charter and the ICJ precedent. I hope that kind of leads you on a research path there.
Yep, it does. Thank you.
We'll take one more. Gentleman's been waiting.
Quickly, just wondering if you could give us an example of what type of state-sponsored cyber attack would trigger the right to self-defense under Article 51.
Okay, so what would be equivalent of an armed attack in cyber? So interestingly enough, I mentioned the dinner with the delegates, the Russian delegates, a couple years ago. So I was the only academic at the dinner, a lot of government officials, and I was the last one. I finally asked a question at the end. The last question I asked, and I was talking a little too fast for the interpreters, so they made me slow down, was I asked the head of the delegation, who was former, he was SVR, they're all kind of intelligence officers, but which is fine by me. I asked him what I'm interested in is what you would consider, what the Russians consider to be an armed attack in cyber. So he laughed and said, we'd have to spend far more time together than at this dinner. So anyway, ever since then I invite him to my conference, and he speaks at my annual conference at Georgetown. I still haven't gotten any answer from him. But we're working on it, meaning that is what the US and other states are looking at. Here's what I think we'll get one day. The US government has kind of given hints of this. So what does Panetta talk about? The Secretary talks about, and General Alexander, and the DNI. They come out and they talk about our critical infrastructure. How important protecting, and DHS I think is listed about 18. Now, not all 18, no offense to somebody who's at the 18th, not all of those critical infrastructures are as important to our national security. But they've identified them as critical infrastructure because if something were to happen to those sectors, our national security would have been in a whole world of hurt, right? So financial sector, energy, IT, water supply. I would say that if you had a use of force by a state against a critical infrastructure, that either the immediate effect or a reasonable-minded standard that the next proximate effect of doing that use of force would be the loss of life, you've got it under an armed attack. So opening up dams through cyber means, the effect, so you're not using a bomb to blow up a building, which would be an armed attack, i.e. 9/11, but you're likely, in doing that, you're opening dams likely to cause deaths. Hospitals, targeting hospitals. So when I said we have room for agreement with states on certain norms, I think the best, where I've spent most of my time is, I believe that there can be room for space for states to agree, and bilateral, trilateral means on certain targets that we're all going to agree to take off the table. And this is what Geneva did, right? And Hague as well, Hague Conventions. Take off certain targets, because all states, believe it or not, all states are very vulnerable to these threats. So can we agree that in conflict, we are not going to target hospitals? Now let's talk about how we technically can identify hospitals on the domain name system, right? So I do think, but loss of life, you know, that's usually a trigger for international law when it comes to what is an armed attack. Clearly, it doesn't have to be limited to loss of life, though, right? In the Tallinn manual, if you're interested, that's what they tried to do. There's no consensus. There was majority and minority opinions of the group that got together, but they tried to take these rules, jus ad bellum in that context, Article 51, but also jus in bello, targeting laws of war, Geneva and Hague, and apply it into those cyber scenarios. So hopefully it's helpful. Thank you. Sorry for keeping you from lunch.